I'm Richard Gill, one of the organisers of the programme here, but I'm here just to introduce Prakken from both Utrecht and Groningen University, and talk about how expert witnesses can use for Bayesian analysis of complex criminal cases.
Nice emphasis. Can everybody at the back hear me? Okay. Well, first of all, thanks you very much, Norman and colleagues, for inviting me. The topic of my talk was perhaps better suited for the first workshop on this project a few weeks ago, but then unfortunately I couldn't be here because it clashed with another conference where I was part of the organization. I should say at the start, I'm explicitly restricting myself to, first of all, court settings, so expert witnesses testifying in court proceedings, and secondly, I'm restricting myself to attempts by experts to give a full analysis of a complex criminal case in terms of Bayesian probability theory. So I'm not, for instance, not talking at all about Bayesian analysis of the evidential value of individual pieces of evidence and so on. That's not the topic of my talk. My talk will be based on two recent practical experiences of myself where I had to appear in court as an expert witness, and I had to comment on, in both cases, on reports written by Frans Alkemade on behalf of the prosecution. Dr. Frans Alkemade, who was a speaker at the first workshop, he is an atmospheric and climate physicist, and in both cases he gave a full analysis of a case in Bayesian terms. First case was a so-called Breda 6 case. Breda is a town in a city in the Netherlands where 6 young people were accused and in the end convicted of robbing a Chinese restaurant after closing time and killing the mother of the owner of the restaurant. And my task then was, according to the court, to assess and evaluate Alkemade's report. This case is finished. The second case, which is still running, is a serial arson case in a small town in the southwest of the Netherlands called Oosterland. And there my task was to assess the reliability of Alkemade's method and its application to the case. So note that in neither of the two cases I was asked to give my alternative analysis of the case. It was more an evaluation of Alkemade's reports. Now, yesterday evening I checked Alkemade's slides of his presentation a few weeks ago. I saw he commented on my report and our subsequent discussions in the Breda 6 case. He writes, among other things, that my report was very critical. That is indeed the case, and that also after some informal discussions we had, most recently in February, some fierce disagreements between us remain. And that is indeed the case. Having said so, I don't want to devote my talk to an explicit discussion of his reports. That would not be fair, I think, but I still think it's important to summarize my main lines of criticism, because especially the two main lines of criticism are more general issues. And my first criticism was, quite bluntly, that Alkemade, being a climate physicist, was not an expert at all on the matters of these cases, which were about robbery and murder and serial arson. And this will be an important theme of my current talk. My second criticism was that the method he actually used, naive Bayes, so with a global independence assumption, even though he didn't use the term naive Bayes, but he explicitly made that global independence assumption, is indeed too naive for complex criminal cases like this one. Really many potential dependencies that have to be accounted for. I will not so much discuss that point today. In addition, I am of the opinion that Alkemade made a number of serious reasoning and modeling errors in both reports, including I think, worrying case of the prosecutor fallacy in his second report about the serial arson case, similar to reasoning fallacies committed by many in the Dutch case of Lucia de Berg, the nurse who was accused of being a serial killer in Dutch hospitals. However, as I said, I don't want to further discuss his particular report. I would like to draw some more general conclusions about how Bayesian analyses of cases could be given in court. And I will a few times maybe use our discussions as an example. I will base myself today on two assumptions. One of them I'm not sure if I agree with it, the other one I do agree with. The first is that Bayesian probability theory is an adequate model of rational reasoning about legal evidence. I think for many of you it's quite uncontroversial, but I also know that in the outside world there are some who doubt this, especially if probabilities are interpreted as degrees of belief or degrees of justification. And then, for instance, Ronald Meester in the first workshop gave a talk where he said, well, in that case, Bayesian probability theory cannot distinguish between uncertainty and ignorance. I have some sympathy for this point of view, but I'm not really an expert in this debate, so for the purpose of this talk, I will simply assume Bayesian thinking is okay, at least in theory. My second assumption I fully agree with, that if you give a Bayesian analysis of a complex legal case, and you want to do it in full, including, as Alkemade did, giving posterior probabilities of the hypotheses you're considering, including the guilt hypotheses, then you really need Bayesian networks. I already said naive Bayes, in my opinion, is really too naive, but even the general version of the chain rule, which doesn't make a global independence assumption, and which was very nicely used by Christian Dahlmann in his presentation at the informal pre-workshop that some of us had Friday and Saturday. Okay, it does take the dependencies, possible dependencies into account, but it still leaves a lot of the reasoning implicit, and I think a strong point of Bayesian networks is that with all these intermediate nodes you can give at least intuitive explanations of the relations between hypotheses and evidence. Another preliminary, sometimes a sharp distinction is made between frequentist and epistemic interpretations or uses of Bayesian probability theory, where if you base your probabilities on frequencies, observed frequencies, then this would give the probabilities objective status. It would be able to justify these probabilities, while if you interpret probabilities as degrees of belief, then they would be no more than purely subjective degrees of beliefs of the person who expresses them. I don't believe in this sharp distinction. I think that may also hold for many of you. First of all, if you use statistics in the objective approach, even selecting and interpreting statistics often requires judgment, assumptions. For instance, in the second case, the serial arson case, Alkemade used statistics about serial arson in Japan and applied them to the small Dutch town. He was well aware he made a leap there, but this is not necessarily objective. On the other hand, if the degrees of beliefs are expressed by experts on the domain at hand, for instance by a DNA expert or a legal psychologist evaluating testimony evidence, then you can say that they are more than purely subjective. And this, by the way, also holds for the judgments involved in interpreting statistics and data. If an expert in the domain at hand expresses them, that also again gives them some objective status. By the way, I should say that in both of the cases there was only little statistical evidence. Most of the probability estimates were not based on reliable or statistics. Okay, so in both cases expertise is important. We all know intuitively it's rational in daily life to rely on what experts say. This can also be given a philosophical foundation. For instance, in argumentation theory, in formal argumentation theory, people analyze expert testimony, and here I have a so-called argument scheme for reasoning with expert testimony formulated by Douglas Walton, famous argumentation theorist. It has three premises. Some person E is expert on a domain D. He says that P is within that domain there, and that if those three things are true, that creates a presumption that indeed P is true, P is the case. However, two things are very important here. First of all, this presumption is defeasible, or in legal terms, rebuttable. Even if all three premises are true, it can nevertheless be rational not to accept the conclusion. And in argumentation theory, that is reflected in sets of critical questions attached to such argumentation schemes. For instance, one recognized question of this scheme is the expert biased? And another critical question is, well, we all know that in academic discussion, for instance, it's experts can rationally disagree with each other. Science is not always fully conclusive. That, of course, creates problems for the court. They are faced with battles of the experts, and by definition, they are not able to decide who is right or who is wrong, because that's why they ask the experts in the first place. I sometimes felt myself in that situation in the court session where both Alkemade and I were interrogated. But anyway, what can you do about it? The second thing that is important to note is that before you can even invoke the presumption that what experts say is true, you must first establish the premises. And in particular, in my case, I think it's very important that the expert giving the Bayesian analysis of a case should not just be an expert on Bayesian probability theory or Bayes networks, but also an expert on the domain of the case. And for instance, in the Breda 6 case, testimony evidence was very important, witness testimony, confessions and denials of suspects. And in fact, there were strong arguments that these confessions of three of the suspects were not real, were false. There was blood spatter evidence in the Breda 6 case, some DNA evidence. In the second case, well, of course, you have to be an expert on arson cases. Again, testimonies of witnesses and denials, in this case, of suspects were important. There's also some sociological issues. At some point, the community turned against the suspect in my case and his friend, who was also in a separate case a suspect, because they supposedly did it together. And well, this will be probably the most important element in my talk. To give a reliable Bayesian modeling of a case, you should really be an expert not just on Bayesian probability theory, but also on all these aspects of the case. Let me briefly give an example from the Breda 6 case. One important piece of evidence there, well, important, yeah. So basically they were convicted on the basis of three confessions of the three women suspects, and the fact that there was this dead body. There was not much more evidence, some hearsay evidence. But there was also some potentially exculpatory evidence, namely at the crime scene, a blood stain had been found, and it had been determined by DNA analysis that the DNA in that blood stain did not belong either to any of the suspects or to the victim or to her close relatives. So if you can have an argument that this blood stain is case related, then of course it's potentially exculpatory. Now, what I didn't know actually when I was interviewed in court and when I wrote my report, but what I found out later is that some weeks earlier, or 1 week earlier, a bloodstain expert had testified that with no degree of probability, conclusions can be drawn concerning the dryness of the bloodstain at the time where it was found. Yes?
Just a matter of interpretation of language here. You're presumably quoting
Yes,
no degree of probability
that's...
can be understood as probability zero.
No, I think what the expert meant to say is not uncertainty, or in this case full certainty that this can be done, but he expressed ignorance. I, as an expert, cannot say anything sensible about whether the blood stain was dry when it was found. And the only evidence actually was a picture of the blood stain, if I'm correct. So I interpret this as the bloodstain expert expressing full ignorance, a refusal to make any probability estimate about whether about the dryness of the bloodstain at the time it was found.
That is certainly one interpretation, but it can be understood as there is no probability that.
No, that's definitely not what he mentioned. You cannot know that, but I have this from the text of the requisitory of the prosecutor, and from that context it becomes clear, I think, that's my opinion, that my interpretation is what the bloodstain expert meant.
Then that would have been understood by the court.
And it was in Dutch.
And it was in
Dutch English is the problem.
Anyway, nevertheless, Alkemade, to my surprise, I think this is remarkable, estimated probabilities concerning this very issue, even though he is a climate physicist and not a bloodstain expert. Okay, now that we know that expertise is important, what questions have to be answered in a case if you want to build a Bayesian network model of a full case? Well, before you can even start estimating probabilities, of course, you have to make various preliminary decisions. For instance, you have to formulate the relevant hypotheses. You have to select the relevant evidence concerning these hypotheses. You have to think about what are the intermediate propositions or variables, if you like, that say something about a relation between the hypotheses and the evidence. Then you have to think about their possible dependency relations. All these things have to be thought about and decided before you can even start estimating the probabilities. Well, and then the question arises, who has to answer all these questions? Now, if I'm right, many forensic scientists give the following answer. We, the forensic scientists, determine the conditional probabilities because of well, how probable is the evidence given the hypotheses that are discussed, because these probabilities can be based on our expertise, maybe DNA expertise or glass expertise or whatever, medical expertise. And the judge, or in a jury-based system, the jury has to determine the prior probabilities because we cannot estimate those probabilities based on our expertise. Now, I think this makes sense, at least, if you think of quite specific analyses of particular pieces of evidence, for instance, given in terms of likelihood ratios, or maybe even small Bayesian networks, as they are now designing them, for instance, at the Dutch Forensic Institute. But this does not really apply to analyses of complex cases with Bayesian networks. Because before you, as I said, before you can even estimate the probabilities, several of these other issues have to be determined. And who selects the relevant hypotheses, evidence, intermediate propositions, who determines their dependencies? Now, I would say, and to some of you this may be, maybe even many, this may be fully obvious, this should be done not by Bayesian experts, but by domain experts. And here it's relevant that you can be an expert of a different kind. We have experts in statistics, we have experts in probability theory. I think many of you are experts in both. But on the other hand, we have experts in a domain, in matters concerning DNA, or footprints, or fingerprints, bloodstains, testimonies, group behavior, arson cases, and so on. And what I think is also quite obvious, but for lawyers, judges, prosecutors, probably not, is that expertise in Bayesian thinking does not at all imply expertise in any of these domains. So I would say these probabilities and all these earlier decisions, they have to be decided by domain experts. However, then some other problems arise. For instance, I think domain experts, although many of them are familiar with likelihood ratio thinking, they will definitely not be familiar or at least comfortable with large-scale analysis of cases in Bayesian terms. Obvious answer to that at first sight is, okay, let the Bayesian expert collaborate with the domain expert. In fact, in my computer science department in Utrecht where I work, there is a group developing medical expert systems, and they would never, medical applications of Bayesian nets, and they would never design them on their own. Of course, they always collaborate with medical experts. But then another problem is, in complex cases, expertise is needed of various kinds. DNA, footprints, testimonies, whatever. Sociology of group behavior or psychology of group behavior. So in general, you would need several domain experts. So it becomes a team effort with at least an expert in Bayesian networks, maybe a statistician also, and domain experts on each of the aspects of the case. But then I believe there are further problems. For instance, in a complex case, many aspects will not be a matter of expertise in some medical forensic sense, but will be common sense issues. To give you one example, in the Breda 6 case, one piece of evidence considered by Alkemade was that two of the female suspects were actually working in a snack bar, as we call in the Netherlands, I'm not sure if it's English, but next door the Chinese restaurant that was robbed. And he claimed that had some, in combination with other pieces of evidence, was incriminating evidence. Now, how can you be an expert on that? This is common sense, I would say, and of course in all legal systems in the West, applying common sense is not the provenance of forensic experts, but of and definitely not of climate physicists, but of the judge in court-based systems and the juries in jury-based systems. So that's a problem. And then there is a different problem. I think, okay, if you look at research on applying Bayesian networks to complex legal cases, quite some wonderful research is going on. For instance, Norman Fenton and his colleagues, Martin Neal, David Lanyado and others, Bart Verheij and I supervised two PhD students on this issue the last 4 years, Stuart Timmer and Charlotte Fleck. All very interesting, extremely interesting research, but I think it's fair to say, if you look at the state of the art, we are still far from a kind of unique, reliable method on how to draw Bayesian networks of full complex cases. And that means that if you have two different teams analyzing a case, and even more so if you have two different individuals analyzing a case, you might very well end up with completely different models. Not just in the probability estimates, but also in the structure. And that creates problems, of course. What should courts should be aware of that. And I think the only real way to make that aware, to make the courts or juries aware of that, is to have not a single model, but at least two teams modeling the case from different perspectives. Could be from the prosecution perspective and the defense perspective, for instance. But remember, this was not asked from me by the court in my cases, and if I had been asked to draw my own either Bayesian or maybe argumentative analysis of the case, I would have refused, because then I think I would have made the same mistake as Alkemade made in thinking that he is an expert on the aspects of the case. Even if you can solve this problem, so you have these two different teams of Bayesian, statistical and domain experts collaborating, and you have in some way solved the common sense reasoning problem. Well, will this really work in practice? So can judges, prosecutors, jury members, advocates can they really make sense of the model, the resulting models? And well, I've become, through my experiences, both as a supervisor of PhD students on this topic and as an expert witness in court, I've become very skeptical about this. The Bayesian way of thinking, the mathematical way of thinking, is far removed from how lawyers, judges, and so on think in practice. And I think it's simply not feasible yet. I mean, some might claim that we simply have to educate them better. I think that will not solve the problem. They should be educated better, especially in Bayesian thinking. I'm doing that myself in Groningen with my law students. I'm giving them 2 lectures on simple Bayesian probability theory, but yeah, in court settings, full analysis in Bayesian style of a complex case. I don't see how judges can make sense of that. Maybe they think they can make sense of that, but then they will always overlook something, and the resulting effect might be misleading. Okay, to conclude, I will tell you about 3 recent cases where Bayesian analysis was used, or the prosecution wanted to use it. So first of all, the Breda 6 case. How did it end? Well, first of all, with a conviction. I have nothing to say about that. That was not my task. The court did rule that Alkemade could be regarded as an expert, with all respect for Alkemade, but I think that was a wrong decision, but because from the text of the decision it seemed that the court only considered whether he could be regarded a Bayesian expert, and I'm prepared to believe that he is one. But they didn't consider whether he could be regarded as an expert on all the aspects of the case. However, a decision that is more in agreement with what I've been telling you is that they said, again my translation, the reliability of the aforementioned method, Bayesian thinking, is, given the state of the art in research, too uncertain to be applied in a complex criminal case such as the present one. For that reason, they disregarded Alkemade's conclusions, although they didn't say we fully disregarded his report and speculate about what that means, but this is at least what they said. And I think this is a wise decision. As I also said on one of my previous slides, we are not yet far enough to have a reliable method to analyze complex cases in Bayesian terms. Second recent decision in the rape and murder case, there the prosecution wanted Alkemade to write a report in the investigative stage of the case, or the pre-trial phase. This phase is supervised by an investigating judge, and the investigating judge in this case did not allow this report by Alkemade. 2 quotes. Apparently, first, there is at this moment not a workable hypothesis, and second, we do not see how such a broad investigation could lead to a conclusion about guilt or innocence. And the defense lawyer was very pleased with this decision. He said, well, deciding on a case dossier is the task of a judge, not of somebody else. And finally, a court in a recent, I think, robbery case disregarded a report by Professor Tom Derksen. Many of you will know him. He did some wonderful work in criticizing the convictions of Lucia de Bay in her case, partly with Richard Gill and others. He wrote a report for the defense, also applying what you could call a naive Bayes, but in a very informal way, not at all in the way Alkemade did, very formal with numbers, mathematical or arithmetical expressions, but in an informal style, almost without numbers. And the court said that the outcome of his Bayesian analysis to a large extent depends on the selection and evaluation of the evidence made by Derksen. The court does not exclude that this method, provided it is used properly, can be a tool in truth finding. So they are not completely opposed to Bayesian thinking. However, they say, but the final answer to the question whether a charge can be lawfully and convincingly, that's the Dutch legal procedural requirement, proven, is not a question that is suitable for probabilistic calculations. Answering this question is the task of the judge. Not sure what you think of this case. I think of this decision. I think it's a good decision, a wise decision. The way I interpret these statements, some room for disagreement maybe here, is that the court correctly sensed that Professor Derrickson, who is a professor in philosophy of science, and also I think an expert in Bayesian reasoning, he was not an expert on the matters of the case, and therefore his method and his analysis, his model, did not have an objective status. So to conclude, the main message I want to tell you is that a Bayesian expert witness in court should refrain from making modeling decisions on matters that are outside the scope of the Bayesian expert's expertise. And if you give a full Bayesian modeling of a complex case, there will be many of such decisions that you should not make. However, if you are a Bayesian and you feel attacked, there is some consolation, because I think this conclusion can be generalized to any kind of reasoning expert, whether a logician, argumentation specialist. I regard myself as at least an attempted specialist, narrative specialist, like maybe the Dutch psychologist Peter van Koppen, or a specialist in combination of these reasoning methods, like Floris Becks, who in his book and PhD thesis combined argumentation and narrative. For all these people, exactly the same recommendation can be made, I think, and this is actually the reason why I was very careful not to express any opinion on probabilities at all in my reports, except if I really felt that I had to, and then I wrote, they are based on my own common sense. Okay, thank you very much for your attention.
Thank you very much, Henry. Questions? Start with Lina.
Hi. So when you say they should refrain from making modeling decisions, I just have a question. First of all, I think, would you agree that common sense can dictate the modeling in terms of the nodes and the arrows, and it's more in the assessment of the probabilities that you think a non-expert can make a big error?
No, I think in many cases this will be a matter of expertise in the domain at hand.
No, but I mean that, you know, somebody lighting this fire would have caused the fire. I mean the basic model without any numbers. It's not as requiring of expertise as...
Some elements might be a matter of common sense, but many other elements will be a matter of domain expertise in evaluating testimonies, evaluating DNA evidence, footprints evidence, bloodstain evidence, whatever.
But don't you think the future of Bayesian networks applied to criminology is just necessarily going to have to contain an element where you can put in a range of probabilities and evaluate the impact of each branch of your network, each different part of your network on the whole, and
well, even before you can...
the impact can be left out in a mathematical way.
First of all, even before you can do sensitivity analysis in that respect, you have to make all these preliminary decisions.
But if you put in a range of
secondly,
preliminary decisions aren't requiring of so much expertise, because you're not saying the probability is so much. You're giving it a possibility.
Yeah, but even suggesting the possibilities might have a misleading effect. So in effect, I think that, well, I honestly think Alkemaar should not have written his reports, but if he then writes his reports, he should at least not have estimated any number, have left that completely to the court.
So I guess my real question is, isn't there a good Bayesian method that can work where you're not estimating numbers, but just working with ranges? Maybe this is a futuristic question.
I don't think so, because of the many preliminary questions regarding structure, independence, relevant evidence that you have to answer first. But who knows? The future will tell.
Yeah. Move from Jane.
Thank you. I really enjoyed that, because I agree with you on the importance of being clear where you're making assumptions, where you're working jointly, and indeed what you're not saying and what you're deferring. But it does strike me that perhaps you have more scope in the criminal cases than would be the case in the UK. For what happens in England and Australia, which is that you get your opposing experts together to agree on a whole series of points and then to state where they disagree, which might give you more scope for getting some agreement on the range of possible models, not merely competing, trying to agree where that happens.
Excuse me,
And the
it
other-
doesn't happen.
You
You think it happens, but it doesn't happen.
I said in the civil.
Oh, I beg your pardon. Yeah.
And the The other thing that I always think is interesting in these cases is to say if you're not using graphical models, which as Phil pointed out don't have to be Bayesian, what alternatives are you using? I think that's quite important.
Yeah, of course. Good question. First of all, the suggestion to get experts to agree and to agree on what it is that they disagree on. Yeah, very good in principle. In this case, our disagreements were so fundamental that it didn't work out at all. So, yeah. Secondly, what else should judges use? Good question. I mean, we had just before this workshop, some of us had an informal pre-workshop where we were analyzing a Dutch murder case from various theoretical perspectives. We will give a presentation on that on Wednesday. We don't know. I mean, I personally think that a kind of informal version of narrative thinking, informed by knowledge of both argumentation and Bayesian thinking, is the way to go. But that's only my current hypothesis. Yeah.
Another question there?
A lawyer's footnote on one of your slides. So you like the quote from the verdict of the first court in the sixth case, and my comment is that it doesn't mean that the court wasn't actually affected by the testimony. Courts may say one thing and do another.
Yeah, very good point. And I fear that they may have been influenced by some aspects of Alkemade's analysis, but there's just no way to discover that. I don't know. Yeah, but it is a genuine cause for concern, yes.
Charles?
Could you say a little bit more about the type of analysis he did? You called it a Bayesian analysis, but maybe...
It was a classical naive Bayes with a twist. So first estimating a prior on the basis of some quite specific pieces of evidence, actually, and then estimating likelihood ratios for the remaining pieces of evidence. With one twist, if he wasn't sure about that pieces of evidence were independent, he grouped them together and estimated the likelihood ratio of that group. And then he multiplied all the numbers. I mean, I should say, even though he explicitly committed to naive Bayes, without using the term, by saying, I assume global independence of all pieces of evidence with this one twist. If you start looking at this report, at various points he was actually violating this assumption by, in determining likelihood ratios for particular pieces of evidence, actually referring to other pieces of evidence. Now, could you say that he was actually soundly using the general version of the chain rule, which does not make the general assumption of independence? I don't think he was consistently doing that. Sometimes
That's what he says to a person like me, and maybe to you also, but he does not, it's not clear in his report that that's what he's doing. Also because either because he does not know what he's doing, or because he's deliberately dumbing it down so that the judges will buy it.
Yeah,
I think both.
Just point out, Franz outlined it is coming back here October the 6th to the 9th visitants, where he is going to explain in more detail exactly what he did, if anybody's interested in being around.
Okay.
Well, as a Bayesian, I agree with many things you have said. Of course, not about the point that there is an ignorance that cannot be measured by probabilities. But I think that the goal is not to create a monster, a Bayesian expert of everything. The goal is to teach forensic scientists good statistics, hopefully Bayesian, for my point of view, so that there are experts in that particular domain who know statistical methods and can apply good statistical methods.
Well, Bayesian thinking is, strictly speaking, not statistics, I would say. But.
Well, and second, I work with a Bayesian forensic scientist who totally agree that giving the posterior probability of the probabilities of the final case is the task of the judge. And the task of the Bayesian expert is to give likelihood ratio Bayesian factor. And just one point, when the Dutch court says that Bayesian analysis depends on the selection and evaluation of the evidence, I say that any kind of analysis depends on the selection of evidence.
Of course.
You know what is the point, I think, is that Bayesian analysis is not, people, judges, lawyers, specialists, don't like Bayesian analysis because it obliges you to make explicit the selection of evidence and make explicit the assumptions on which your evidence is based.
Okay, you made three very interesting points, I think. First of all, I fully agree that your goals with studying Bayesian methods in forensic science are completely worthwhile, but I note that Alkemade and also the Dutch Public Prosecution Office apparently disagree. They think that really this can now already be usefully applied in practice on such a full scale. I find that very worrying. I believe my story was completely obvious, probably to all of us, or at least almost all of us. So why is this still happening? I find this worrying. Second point was, yes, any reasoning method, of course, works on the basis of assumptions or particular selections and evaluations of the evidence. Any reasoning method. I think the court's point was to acknowledge that, to say Derkson's selection and evaluation cannot be based on objective grounds, therefore we don't have to stick to it. We can make our own choice. They explicitly said we make a different selection and evaluation than Derkson. I didn't translate that on the slide, but that comes directly after my quotes. I forgot about your third point. The reason why judges don't like Bayesian analysis is that you are forced to make your assumptions explicit. Good point, again.
One of the reasons.
There could be, I think, other reasoning models like argumentation and narrative, if applied in a proper way, would also to some extent force you to make some assumptions explicit. But that's a matter for scientific debate.
I'm very sympathetic to a number of things, much of what you said. I think one of the key phrases, though, in your last slide was the scope, outside the scope of the expert's expertise, and I think there's a question of what the expert's expertise is. So I was taught when I was first learning that part of the art of being a good applied statistician is you have a conversation with the client and you learn how to engage in a dialogue so that you extract the information necessary to apply your tools. So there are some areas such as epidemiology that are sufficiently complex that can be risky, but you certainly don't have to be an expert, say, in legal economics to do an analysis of employment discrimination. So it seems to me, what's the scope of the expert's expertise? The reason I have a concern on that is, as a practical matter, I've seen it go in the opposite direction. We'll have a DNA lab technician who knows absolutely nothing about statistics, who will be confidently explaining about the statistics, but on the other side, a statistician who comes in to challenge that can get excluded on the grounds that they're not a human geneticist, they're not a DNA forensic scientist, and so on. And so the trouble is that this knife, can cut both ways and be used to exclude one group of people, but not necessarily the other. Personally, I think it's often the ideal thing is to have a collaboration where you have both the statistical expertise and the substantive expertise. But that's sometimes useful more for protecting yourself in court, in the sense that you may actually know enough, but it's useful to be able to base your statistical analysis on the supporting report of someone else, even though if you've worked 50 cases in this area, substantively you're actually just as well equipped. So I think I'd underline that when you say the scope of the expert's expertise, it seems to me that's not always clear.
That may very well be that it's not always clear, and then you have, as a court, you have a problem. Can we believe this expert? I think in this case it was quite clear that the climate physicist didn't have expertise on all these matters. In other cases it might be that, for instance, Norman Fenton, by way of his many years of experience in modeling decision making in Bayesian ways in many areas, does acquire some expertise in some aspects that are relevant to a case, yes. but that would have to be checked in that individual case where Norman Fenton would give a testimony. So I'm not giving a very sharp line. A Bayesian should never ever say something about domain matters. No, but as a general rule, I think this still applies, and we should especially emphasize this because I'm worried that, at least in the Netherlands, I don't know about your jurisdiction, lawyers, judges, prosecutors are not always aware of this distinction. They are maybe quite easily impressed by the scientific nature and the mathematical nature of the testimonies, and they don't actually see that expertise in Bayes doesn't imply at all expertise on the domain on which you are estimating the probabilities and making all these other decisions. That's my main worry and the reason why I gave this talk, based on my experiences.
Okay. Well, I think we should please continue this discussion over lunch. And let's thank Henrik.